right now we'd like to bring in one of our own team members, Kurt Palmer, who is director of our custom media. We're really excited about what we're doing around custom media and enabling our solution providers specifically to do some really unique things, with our community. And Kurt, good morning to you.
Good morning. Thanks for having me. I appreciate being with you today.
Yeah, good to have you on today.
I don't know. Maybe we should just share with our audience why we were so excited to get Kurt involved with us and the Institute for Healthcare Consumerism. Kurt's background is absolutely extraordinary when it comes to, working with our clients and our audience, our marketplace. He's been a VP with Cigna Healthcare. He's worked with Healthion and WebMD. Kurt has been not only a member of the HSA Council, but an active leader with that organization. He's been with startups. He's been with major Fortune 100 companies like MasterCard as a business leader of healthcare solutions. And he is skilled in understanding how to make content marketing work for organizations. So, Kurt, we're really thrilled to have you as part of our team.
Yeah, and I think the other aspect of what we're doing is that utilizing video, providing video services to our marketplace. Being able to do custom things. That word is maybe a little overused, but our marketers have a unique opportunity to utilize our events and our other platforms, but there's some unique needs they have, and that's really why we're doing this whole custom media and content marketing initiative, enabling our marketers and the solution providers to leverage the credibility and the resources we have here around content, to leverage our community, and to do some local things and some really specific things.
Beyond the marketers and solution providers, really anybody who's trying to persuade an audience to change their behavior in some way, including our employers, might benefit from taking our content and or letting us create content with them. So, Kurt, we'll shut up. Tell us what's happening, man.
I appreciate the introduction, and I think our listeners appreciate also that IHC has done great things with the forums and the publications and this radio program itself, to help people share information and learn about trends and meet colleagues, all to do with healthcare consumerism. And, I believe very strongly that there's tremendous opportunity. This is the way the industry is headed, and doing so in a major way. I think the challenge is for our affiliate members to separate themselves from all that's out there, all the information, all the different opportunities and offerings, and really to find their targeted audience, with custom media, with custom events, things that are content driven. And this can be accomplished in a variety of different ways. We've come up with a series or a suite of services that we can help and expand our affiliate members' thought leadership and their brand. And we've targeted these things in a couple of ways. Roadshow events. So if you have a particular audience that you want to address and attract in a particular geography, we can support you in getting that group together, putting together a panel of experts, including you as the affiliate member or those you want to invite as your guests. We can videotape that event. We can make that event, publish it on your website, on our website. It can be distributed in ways that you want to through social media. We also have introduced, and we did this in our Las Vegas show, I think very successfully, the executive interview, where we, using our platform and being the voice of healthcare consumerism as a credible, trusted source of information, can sit down with executives from your company and talk about the things that affect the industry, or talk about topics that are important to your audience and your prospects and your buyers, and have a conversation while, again, reinforcing the thought leadership that you bring to the discussion, That gets videotaped, and again, the same as with the road shows, we can distribute the videotape of that, with logos and all of your branding to any distribution that you would like. We will use it on our website as well to promote that event or promote that discussion. So, and of course, webinars is another way to address a targeted audience on a particular topic. So, all of these things are done to help really build and extend your brand, establish or strengthen your thought leadership, really get with a live targeted audience, and ultimately drive sales and demand for the services that you as our affiliate members are bringing to the marketplace. So in a nutshell, that's really what we're trying to accomplish with the whole custom media and content marketing approach.
That's good. That's great, Kurt. Hey, got about 30 seconds here. Tell our audience how they can find out more and how they can connect with you.
Well, you can certainly contact your IHC account manager. You can contact me directly at cpalmer@theihcc.com. Phone number 860-670-6391, and I'd be happy to spend time and talk through your marketing plans and anything we can do to support you.
All right. Hey, Kurt, thanks. Have a great weekend. And to our audience, you can also find some more information on our website under custom media on our website as well. Thanks, Kurt. Appreciate it.
Let me thank you, Kurt. Let's shift to our first interview guest. That's Stan Hill, who is an attorney with Polsinelli. As I mentioned, it's one of the largest firms in the country, and they have really one of the top, if not the top, healthcare practice. And Stan is an expert in understanding some of the information and data security challenges that come up in the healthcare space, and he's been doing a lot of thinking, a lot of work around the issues related to wearable technologies in the workplace. Stan, thank you for joining us. We look forward to the conversation.
Yes, thank you. It's great to be here.
Just say a little bit more about the work that you've been doing, just so our audience has some more context about where you get your expertise on this subject.
Well, I'm an employment attorney, spending most of my time both litigating employment cases and advising employers on the various and sundry employment laws that arise under federal law, under state law, and under local laws throughout the country. I sit here in Atlanta, Georgia, and the firm, the group here in Atlanta has been with the Polsinelli firm now for about 2 years, and it's been very exciting to sort of to become integrated in with a larger firm nationwide with such a large and dynamic healthcare practice. And part of my practice does touch on sort of the intersection of the employment law issues with some of the emerging technology, both that employees are bringing into the workplace and that employers are seeking to bring into the workplace. And as you may know, part of the innovation does touch in the healthcare space and implicates some privacy issues as well.
Hey, Stan, this is Doug, and again, I welcome you too and appreciate your time. Wearables are an exciting new piece of technology that's out there. It provides a unique opportunity to get personal with these employees, but that's also the big red flag. I mean, what are the concerns out there that you see that employers need to be aware of around wearables?
Sure. So I think conceptually, it's helpful for employers to think about two issues. The first being employees bringing their own personal wearables into the workplace. And second, if the employer is considering leveraging wearables and the technology that it offers, what laws and what concerns should they be thinking about before they bring this new technology into the workplace and tell employees, hey, put these glasses on, put this on your wrist, wear this device on your body. And those are two very different sets of challenges, and but ones that really need to be thought through at the outset, because the old adage goes, an ounce of prevention is worth a pound of cure, and that's certainly the case here as the laws are really will lag behind as they always do when it comes to technology.
Yeah, you talked a little bit about privacy, in your introduction. What is the concern around privacy issues with, employers and their employees?
Well, primarily from the employment law perspective, employers need to hold any medical information that they may acquire by their employees in a separate file.
Right.
And generally that comes up in the context of when an employee needs an accommodation or requests an accommodation for a disability or seeks to take a leave of absence under the Family Medical Leave Act, and sometimes medical information is acquired in those circumstances. And that's primarily sort of one of the day-to-day bread and butter challenges an employer might face, and that's something to definitely keep on the forefront of the mind. Another related point is that there is HIPAA, of course, that I'm sure many of the listeners are familiar with or we've heard a little bit about. And it's important to keep in mind that HIPAA is a law that applies to covered entities, and that's a term that's defined under that law. But there are situations where if an employer puts on the hat of, say, sponsoring a group health plan, where that law is implicated and employers need to be concerned. I think one of the emerging challenges that employers might face going forward, particularly as technology becomes integrated into the business, and that technology implicates employees' movements and potentially health information, is the employer wearing the hat of an employer, or is the employer wearing the hat of a covered entity under which the privacy regulations of HIPAA might apply? And really, that question is one that needs to be addressed from the outset. So before an employer decides to bring in some sort of wearable technology that might gather some data that might be related to an employee's health information, that data be analyzed and a discussion be given to, well, what exactly is this data? What does it show? What could it show? And if it does touch on health information and it does get into the realm of the group health plan, is HIPAA involved? And do we need to take additional precautions to make sure that this data is properly stored?
Now, Stan, this applies to not just wearables, but it also applies to any of the new remote monitoring devices that are being introduced to the market too, that somebody might not wear all the time, but they're accessing and it's reporting data back, right?
Right, and it ultimately will primarily depend on what exactly that data is that's being gathered. And oftentimes, when it comes to the world of big data, computers are gathering data in a variety of different ways, and we may only be seeing that or appreciating one or a few different components of that data and not all of the different streams of data that a device might be gathering and storing. And ultimately, an employer's obligations under the law depend not only just on what the employer is considering day to day and what they're looking at, but ultimately the data that they actually store and acquire. And managing all of that data, not just what the employer might be focusing on at any particular time, is important. And again, it's easiest to cover the bases at the outset before the data starts coming in, before the data is lost into the ether of various and sundry servers and systems and cloud-based storage. So again, it's very important to think through these things at the outset and consider consulting with an attorney in these areas.
Yeah, you're not advising against using it. You're just saying, hey, here's some things to be aware of if you're going to utilize them. Correct?
Absolutely. I think there's some powerful tools out there, and a lot of it is industry specific. Yep. So it's just as an employer thinks about and a business thinks about, leveraging technology in any way that might implicate any sort of biometric data or any data where it's coming directly off the employee, being the eyes and ears of the employee. There's privacy concerns there. One thing that I hadn't mentioned, but is something employers should consider, is is particularly if it's something even as simple, and I say simple, but in sort of a sarcastic way, but even it's something as simple as Google Glass or a camera, a body camera. There are privacy interests there potentially, and again, this is a law that depends state to state. So another reason to perhaps consult an attorney before it's implemented. But if you have this body camera, a question becomes, well, does the employee have some sort of expectation of privacy in what this camera is showing? And what can the employer do to inform the employee so that expectation of privacy is removed and that everyone is aligned as to what the data can and will be used for? So in a situation like that, and generally in any situation where technology is leveraged to gather data about an employee passively, even something like email that's sort of ubiquitous now, employers should consider having a policy, perhaps in their employee handbook, explaining, the technology that's being used in the workplace, and that the employee does not have any expectation of personal privacy in the use of the technology, and that frees up the employer to use the data and view the data without a later concern of the employee coming back and saying, well, this data, I expected this to be private, when in fact it was not.
Can you talk to us a little bit about, and I think about things like tracking employee movements, especially things like that have to do, may link to performance or could be linked to performance in some way, not just health, but work performance. I especially wonder how unions are responding to that, and how they're getting in the way of or facilitating these wellness programs that include wearables. Can you speak to that a little bit?
Sure. That's a very multifaceted question, and the classic attorney answer, it depends, will come up in my answer a few times here. But generally, I think it's important, to start with the sort of the law in this union sphere, and something that the listeners may or may not be aware of is that one of the major laws in this country affecting union workplaces, but also non-union workplaces, is the National Labor Relations Act. I think most people would sort of jump to the conclusion, well, that only applies if you have a unionized workforce, but it doesn't. And really, I think one of and we're seeing this in the case law and the decisions that are being issued, the National Labor Relations Board has responded to sort of the decline of unions nationwide with more enforcement initiatives against non-union employers under this law. And in particular, one of the areas of the law that all employers should be aware of is Section 7 of the National Labor Relations Act, which, in a nutshell, enables employees who are not supervisors or management to engage in what's called concerted activity for mutual aid or protection, which can be some things like discussing the terms and conditions of work or discussing their wages. Really anything that touches on how the employee performs the work or the conditions of work, employees are free to talk about amongst themselves without retaliation by an employer. And as technology has emerged in the workplace, both personal devices and the devices that an employer might provide, there's a whole new host of issues about when can employees engage in these concerted protected activities using these devices, and when does the employer have the right to tell the employee, look, you're on the clock, you're on my time, you can't do this now, you're supposed to be working, or you're using my device. That's one of the big questions now. Can employees engage in these activities using work computers, using their cell phones and other devices like walkie-talkies or chat systems that the employer provides? And these sort of time, place, and manner questions are all being fleshed out right now, and it's a very dynamic area of the law, and one that really it's best addressed from the circumstances of each individual employer. Because as you can imagine, an employer's business needs and objectives are much different in an environment like a warehouse or a manufacturing facility than they might be in an office environment. So to tie it all back together, really all these various issues, it's very easy to have a discussion from my perspective as an attorney, as a counselor, as an advisor to a business, going through an employee handbook and making sure that it's updated. And that's something that I think all employers, should have an employee handbook, should consider having an employee handbook, and having it regularly updated and making sure that it's in line with these areas of the law that are evolving with technology. And to that point, having policies in an employee handbook that address things like expectations of privacy when using technology in the workplace, and what uses of these technologies are permissible. If we consider, say, an employer that brings in technology into the workplace and says to the employees, well, now perform your job using this technology, an employer needs to be concerned about how that technology could be misused by an employee, not only perhaps to hamper productivity or impair the work of others, but also, is there confidential and proprietary information that is locked up in this device or that is locked up in the way this device is used, and how does the employer protect that trade secret or confidential information day to day? And those are all, again, conversations that are best had at the outset so that the procedures and the policies are laid in place before the technology is introduced into the workplace.
Well, so we're running tight on time, so I have just two questions to wrap up. One simply, sort of personal. What Doug wants to embed a chip in me to track me. No, that's not really a question. So can you just, if you could tie this in a bow for our audience, what are a couple of things that you want to make sure that our listeners take away from this conversation?
Sure. Well, I think the first thing is, it goes back to what I've said a few times, that an ounce of prevention is worth a pound of cure. And an employer should think very carefully about the various laws that might be implicated in any technology that the employer brings into the workplace or that the employer allows employees to bring into the workplace. And second to that is that the law seems to always be trying to catch up with technology. And one of the ways an employer can best reduce the risk of having any legal claims or issues is to have vigilant review of their policies and procedures to make sure that the policies and procedures not only keep up with the law, but also keep up with the technology that might implicate issues the law has not yet addressed.
Mm-hmm. Gotcha. So it's time for everybody to review their policies and their handbooks, and sounds like, among others, you are expert in helping at that. Can you just let our audience know how best to reach you to learn more?
Sure. Well, I would encourage everyone, a good way to stay abreast with some of the emerging issues is to visit our blog, which is polsinelliatwork.com, polsinelliatwork.com. And also to view our website, we've got a tremendous resource of e-alerts and articles written by our attorneys in the healthcare and employment areas on emerging issues and how the law has changed. And it's a great resource and a good jumping off point to speak with one of us if anyone has a question.
Great. Well, thanks so much. We look forward to
thank you for having me.
Talking with you more as this world changes so fast and the challenges related to privacy and employer information change with it. So appreciate it.
Yes, thank you for having me.
Thanks, Dan, very much. Appreciate it.